Judge blocks expedited deportations. Court signals Trump's birthright citizenship order may be unconstitutional. USCIS issues new rules for family immigration, and Trump administration sets new border crossing record. Recent developments in U.S. immigration policy and enforcement have sparked nationwide attention, involving federal court rulings, policy updates from USCIS, and record-breaking shifts in border activity under the Trump administration. If you are interested in this topic, please pay attention and watch the video through to the end to get all the information. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. Judge blocks expedited deportations of those who entered the U.S. legally, possibly curtailing ICE courthouse arrests. A federal judge on Friday blocked the Trump administration from rapidly deporting migrants who entered the U.S. legally on humanitarian grounds, potentially curtailing arrests at immigration courts that have triggered controversy across the country. U.S. District Judge Jacob of Washington, D.C., barred federal immigration officials from using two Trump administration directives to apply a fast-track deportation process known as expedited removal on migrants who were granted immigration parole to enter the U.S. at an official port of entry. Parole is an immigration authority that allows federal officials to admit foreigners on humanitarian grounds and lets them live and work in the U.S. legally on a temporary basis. If left in place, Cobb's ruling could significantly hinder the Trump administration's aggressive efforts to ramp up its mass deportation campaign by targeting migrants allowed into the U.S. under the Biden administration through the parole authority. The Justice Department is expected to appeal her order. One operation in particular that could be curtailed by Cobb's ruling is a Trump administration effort to convince immigration judges to dismiss the court cases of certain migrants, so that immigration and customs enforcement agents can arrest them after their hearings and place them in expedited removal. Unlike immigration court cases, which typically take years to complete due to a backlog of millions of unresolved claims, expedited removal allows officials to more quickly deport migrants who arrived to the U.S. in the past 2 years. Those placed in that process face summary deportation from the U.S. unless they express concerns of being persecuted in their home countries and prove to an asylum officer that their fear is credible. The courthouse arrests have been reported in cities across the U.S., with videos emerging showing ICE officials detaining migrants immediately after their hearings conclude. In some cases, those taken into custody have been seen weeping and visibly distraught. The practice has been strongly decried by Democratic lawmakers and advocates who say it punishes people who are trying to follow the legal process by showing up to their hearings. In her opinion, Cobb found the Trump administration's efforts to be illegal, saying the lawsuit against the expedited deportations raised a question of fair play. She noted the plaintiffs in the case, two migrants from Cuba and Venezuela, had played by the rules, entered the country with the government's permission, and attended their court hearings, and were nonetheless targeted for expedited deportation. This case's underlying question, then, asks whether parolees who escape oppression will have the chance to plead their case within a system of rules, Cobb wrote. Or, alternatively, will they be summarily removed from a country that, as they are swept up at checkpoints and outside courtrooms, often by plainclothes officers, may look to them more and more like the countries from which they tried to escape? Stephen Yalur, an expert in U.S. immigration law, said Cobb's order could mean that several 100,000 people will be temporarily spared from immediate removal under the expedited removal procedures. Yalur noted the ruling as a reprieve for many of the more than 500,000 Cubans, Haitians, Nicaraguans, and Venezuelans who were allowed into the U.S. through parole authority under a Biden administration sponsorship policy. It also protects some of the nearly 1 million migrants paroled into the U.S. along the southern border under another Biden-era policy powered by a now-discontinued phone app known as CBP One. In a statement, DHS Assistant Secretary for Public Affairs Tricia McLaughlin denounced Friday's order. This ruling is lawless and won't stand, McLaughlin said. Trump's birthright citizenship, U.S. Supreme Courts, Jacob of the U.S. District Court in Washington, D.C., the Department of Homeland Security's U.S. Appeals Court indicates it might declare Trump's birthright citizenship order unconstitutional. Donald Trump's executive order seeking to deny birthright citizenship to U.S.-born children of undocumented immigrants is facing intense legal challenges and mounting judicial opposition. The Ninth Circuit Court of Appeals in San Francisco has already declared the order unconstitutional, and the First Circuit Court of Appeals in Boston appears poised to do the same. A three-judge panel in the First Circuit expressed deep skepticism during a recent hearing, questioning the federal government's rationale for overturning previous rulings that had blocked the order's enforcement. Their inquiries focus heavily on historical legal precedent, particularly the Supreme Court's 1898 decision in United States versus Wong Kim Ark, which has long been interpreted to guarantee citizenship to all children born on American soil, regardless of their parents' immigration status. Despite a June 2025 U.S. Supreme Court ruling that curtailed the ability of judges to issue broad, nationwide injunctions, lower courts in Massachusetts and New Hampshire were still able to issue new orders blocking Trump's executive action from taking effect nationwide. These courts relied on exceptions outlined in the High Court's decision, which permitted such rulings under specific circumstances. Judges Leo Sorokin in Boston and another federal judge in New Hampshire reaffirmed and expanded earlier decisions, halting the policy on a nationwide basis. These decisions were supported by challenges from 18 Democratic-led states and the District of Columbia, who argued that Trump's order violates the Constitution. The Justice Department, defending the order, maintained that the 14th Amendment Citizenship Clause was intended only to apply to formerly enslaved Black Americans after the Civil War and did not extend constitutional rights to U.S.-born children of undocumented immigrants. Eric MacArthur, representing the DOJ, argued that these children should not be entitled to automatic citizenship. However, the judges on the First Circuit panel found this reasoning incompatible with long-standing interpretations of the 14th Amendment and emphasized their obligation to follow binding Supreme Court precedent. Chief Judge David Barron, along with his colleagues, clearly indicated that they could not disregard the Wong Kim Ark ruling simply because the government now wants to reinterpret it. In a separate immigration-related development, issued an order blocking the Biden administration from expediting the deportation of potentially hundreds of thousands of migrants who have been paroled into the country for humanitarian reasons. The Department of Homeland Security's plan to initiate swift removals was challenged on grounds that such actions could cause irreparable harm to individuals awaiting regular immigration proceedings. Judge Cobb emphasized that pausing these deportations was in the public interest. Collectively, these court rulings reflect a consistent judicial effort to safeguard constitutional rights and prevent executive overreach on immigration matters. Trump's Birthright citizenship order has been universally blocked by federal courts reviewing it, signaling an almost certain path to eventual defeat. Meanwhile, the judiciary remains a critical check on immigration policies that risk undermining legal protections for vulnerable populations. Family-based immigration policy. Form I-130, Petition for Alien Relative. USCIS issues guidance regarding family-based immigration policy. U.S. Citizenship and Immigration Services is issuing policy guidance in the USCIS policy manual that will enhance our capability to screen and vet family-based immigrant visa petitions. This video explains requirements and adjudication of these petitions, including eligibility criteria, filing, interviews, and decisions. Fraudulent, frivolous, or otherwise non-meritorious family-based immigrant visa petitions erode confidence in family-based pathways to lawful permanent resident status and undermine family unity in the United States. This video will improve USCIS capacity to vet qualifying marriages and family relationships to ensure they are genuine, verifiable, and compliant with all applicable laws. USCIS is prioritizing robust alien screening and vetting that protects Americans from potential national security threats. We are committed to keeping Americans safe by detecting aliens with potentially harmful intent, so they can be processed for removal from the United States. This video clarifies certain requirements for family-based immigrants by incorporating existing guidance on general eligibility criteria and filing and documentation requirements for family-based immigrant petitions, explaining how we adjudicate family-based immigrant petitions that are filed with related petitions or multiple petitions, explaining circumstances in which we authorize the U.S. Department of State to accept Form I-130, Petition for Alien Relative, filed directly abroad by a U.S. citizen for an immediate relative, including petitions filed by U.S. military and certain U.S. government personnel stationed or assigned outside the United States, and temporary authorizations for large-scale disruptive events, incorporating existing guidance explaining when we will route an approved petition to the DOS National Visa Center, including circumstances where the beneficiary filed an application to adjust status, but USCIS becomes aware of the beneficiary's ineligibility to adjust. Clarify when we require interviews for family-based immigrant visa petitions, and clarifying that we may issue a notice to appear if the alien beneficiary is otherwise removable, since a family-based immigrant visa petition does not grant immigration status or relief from removal. This video will be effective upon publication and applies to pending requests and those filed on or after the publication date. Trump admin sets new illegal border crossing record. Department of Homeland Security. Kristi Noem, U.S. Border Patrol. DHS. Trump admin sets new illegal border crossing record. A new record low number of daily illegal immigrant crossings was set on the United States-Mexico border in July. The Department of Homeland Security said Friday. July 20th saw 88 people arrested by the U.S. Border Patrol, making it the lowest daily number in Customs and Border Protection history. Why it matters. President Donald Trump returned to the White House, promising a secure southern border and an end to high illegal entries. After record highs during the Biden administration, numbers had steadily fallen across 2024, but fell even faster following his inauguration in January. What to know? The DHS announced preliminary border data for July on Friday, touting that history had been made again with low numbers of apprehensions by the Border Patrol. Looking at the southwest border, alone the region which saw the greatest flow of new arrivals during recent years, CBP made 4,598 arrests between legal ports of entry, around 500 fewer than daily averages seen at points between early 2021 and December 2024. That month, the total number was close to 250,000 arrests. Trump and Secretary of Homeland Security Kristi Noem have proudly stated that it was the president's return office and his strong messaging that has stemmed the flow of immigrants seeking entry into the U.S. from Mexico. Earlier this week, the DHS also gave Trump credit for a drastic fall in immigrants passing through the Darien Gap in Panama, a notoriously dangerous jungle route taken by those traveling north from South America, often aiming to get to the U.S. Crossings fell 99.98% during May and June 2025, the DHS said, with just 13 and 10 respectively per Panama government data reviewed by Newsweek, down from a high of around 82,000 during the Biden administration. While the DHS appeared to blame the president for the peak, it was also his administration that began a partnership with Panama to reduce the flow. Along the U.S. borders, CBP has seen a nationwide drop in Border Patrol encounters, with 6,177 arrests across the country, surpassing June's low. Daily apprehensions were at an average of 148, compared to the 152 every 2 hours last July. The DHS said, "What people are saying." DHS Secretary Kristi Noem, in a press release, President Trump didn't manage just the crisis, he obliterated it. No more excuses. No more releases. We put the cartels on defense and taken our border back. Republican strategist Matt Wiley told Newsweek in May that Trump should be making more the fall. If Trump would show up at the border and really highlight this and do this in a way that makes sense, very presidential, bring in other members of Congress, it could be a lift, not just for president, but for Republicans on this issue. What happens next? Illegal border crossings also fell in early 2017 when Trump first entered the White House, before climbing again months later. It remains to be seen if longer-term policy changes will be introduced to prevent another steep rise in illegal crossings. This video underscores the growing role of the judiciary in checking executive immigration actions, while federal agencies refine enforcement and adjudication procedures. As legal protections are reaffirmed and border control tightens, the future of U.S. immigration remains shaped by a complex balance of policy, law, and humanitarian considerations. That is all for today in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully, the information is useful to you. See you later in the next video. Till then, take care.
US Immigration Breaking Update 2025. A federal judge in Washington, D.C. has blocked the Trump administration from using expedited deportation on migrants who entered the U.S. legally under humanitarian parole. Judge Rhea COB rule, this practice violated fairness and due process, protecting over 5 lakh migrants, mainly from Cuba, Venezuela, and Haiti, from immediate deportation under Biden-era program. Simultaneously, federal courts continue to reject Trump's challenge to birthright citizenship, upholding the 14th Amendment based on the landmark 1898 Wong Kim-er decision. Meanwhile, USCIS has issued a new policy guidance to enhance the integrity of a family-based immigration. It vetoes stricter waiting standards, interview requirements, and documentation rules, and clarifies that approved pretension do not confer lawful status. It also aims to identify and prevent fraudulent or non-meritorious pretension. In border security, DHS reported a historic low of just 88 illegal border crossings on July 20, 2025, the lowest in the border patrol history, attributing the drop to Trump-era enforcement measures and reduced migration through the Darien Gap.